Hey guys, we are moving into law for the health professionals. I will say that this is not my favorite chapter, so I anticipate this going fairly quickly today. So your objectives is describe the source of law, give an example of types of law, types of court subpoenas, and the trial process. Some of this you should already sort of know. I'm sure that we've reviewed some of this already in fundamentals, which was quite some time ago. I understand that. So some of it will be a little bit of review. So your sources of law, your U.S. Constitution is the highest judicial authority, and it was adopted in 1787. There are 3 branches under the federal government. Do you know what they are? There's legislative, executive, and judicial. So legislative is the lawmaking body called Congress, and executive is the administrator of the law. This is where the president is included. And then there's judicial, which is the judges and courts, including the Supreme Court. Each branch provides a system check for the other 2, and not one branch has absolute authority. There are types of law: criminal, civil, administrative, and then there's 2 basic types, which is common and statutory. So we all know what criminal is. We've understood that before. Civil is relations between individual corporations or governing bodies. This is sort of the bulk of the healthcare law with workers' comp. It's more monetary. And then there's administrative. An extension of statutory law affects healthcare employees. So the state health department, the state board of medical examiners, and the state board of nurse examiners are all under that portion. Again, the 2 basic types are common and statutory. Common is the judge-made law or case law. That's always evolving. It's always changing. So we need to make sure that we're keeping up with that. And statutory is making up the bulk of the laws. Our Practice Act actually falls under the statutory. So understanding that as well. Criminal law. This is court actions brought by a state against an individual or groups of people accused of committing a crime. The punishment is to those who violate either fines or imprisonment. They must be proven guilty beyond a reasonable doubt. And then it says in the book, the recovery of rights of society. Really, the police officers are working for the society to keep our rights upheld and recovering them through fines and imprisonment received for the plaintiff. So let's say your car got stolen. Well, you have the right to that not happening to you. So the courts uphold that right for you. There are felony and misdemeanors. The definitions are here on the slide. A felony is a crime, typically one involving violence, regarded as more serious than a misdemeanor, and usually punishable by imprisonment for more than 1 year or by death. And this is your murder, larceny, assault, or rape. That's typically held under here. Your misdemeanors are a non-indictable offense, regarded in the U.S. as less serious than a felony. So your disorderly conducts, your breaking and entering, your thefts of small amounts. There are a few different types of court that you could see. There's a small claims court, which is a file action against a client for unpaid or delinquent amounts. There's a probate court, which oversees a distribution of a person's estate upon death. This can help collect any unpaid bills at that time. There's a state court. This is per state, but it does have different levels. So there's typically a district or municipal court, and then moves to the state superior court, which moves to the state court of appeals, and then the state Supreme Court, which is that highest level. There's a federal or federal crimes or constitutional issues, civil action with parties not in the same state. And what is the highest federal court system? That is the U.S. Supreme Court. You might need to know that. Subpoenas. Now we're starting to think about what we see in our line of occupation. So a subpoena is an order to appear in court. The real name for it is a subpoena ducis tecum. This is a written order ordering a person to attend a court and bring any relevant documents. They might do a deposition, which is other than A deposition is not having to appear actually in court, but it is an out-of-court testimony of a witness that is reduced to writing for use in court. This happened to my PT regarding one of my patients, so don't think that it's not going to happen. This is one of the reasons why my documentation really saved me. It was a patient that I saw most of the time, except for the occasional reeval. I was treating them, changing their plan of care, all of that information. But because my PT was signing off on all of my notes, he had to go to court for the issue. Now, what saved me was all of my documentation. I wrote everything down, and it proved that nothing had happened in the clinic that could prove us wrong. So the trial process. Sorry, I apologize about that. I had to pause the video there for a second. So typically the trial process is if they are selecting a jury is selected. I have never served on a jury before. I got selected once, but then they canceled me because I was a healthcare provider. So they decided they didn't need me that much. But typically the case is tried by a judge or a judge and a jury. There are opening statements by each attorney. The plaintiff starts, and then there's a direct examination. So let's say the plaintiff calls their first witness, they ask them their questions, and then the cross-examination. So then the defendant's attorney will ask the questions to the plaintiff's witness, and then they will flip-flop. So then the defendants will call their witnesses, and the plaintiff will ask their questions on a cross-examination. There's closing arguments, sort of like an opening statements. The closing statements are the same, and then there's a verdict. Sort of understood. And then there's a ruling. Are you guilty or not? So there is a thing called an expert witness. I have never heard of a PTA being called as an expert witness, but you can be called as a PT. It is a professional or a person specifically qualified in medicine who can testify in court as to that professional standard. So it's essential when the subject is beyond understanding of a person. So we want to know what the PT would have done. Did the PT do the right thing, or should they have done something different? This happens with physicians a lot. Did the physician act in a reasonable manner? Is it something that this physician would have done? It's just looking for a professional opinion, basically. They testify as what they see, hears, knows to be a fact, an organized standard of care. What do they normally do? And you can get paid for that, which is kind of nice. There is a statute of limitations or a statute prescribing a period of limitation for the bringing of certain kinds of legal action. This varies from state to state. It's hard for me to say what exactly is different from each one. Different from each state, and it's also varies from crime to crime too, so it's dependent on what exactly happened and what state it happened in. Typically it starts at the time of the negligent act was allegedly committed, when the client discovered or should have discovered negligence, or when care, treatment, or provider care relationship ended. Usually with minors it doesn't start until they are of legal age, and then the statute of limitations starts. So if it happened when they were 10, that statute of limitations doesn't actually start until they're 18, and then it goes from whatever years at that point. So in a case of injury to an individual, the statute of limitations is 1 year in Louisiana, it's 6 years in Maine, and it's 10 years in Oregon. So, I mean, you can see right there how drastically different it can be. So that is the end of that chapter. If you have any questions, please let me know. Thanks. Bye-bye.